So it is the end of the Assured Shorthold Tenancy Agreement. It is being replaced by the Assured Tenancy under the Renters' Rights Act 2025. Now this change is expected to come into force on the 1st of May 2026. So it is the end of fixed term tenancies, it is the end of the Section 21 notice. And there are some changes to the flexibility that a landlord currently has when granting a statutory tenancy. The first thing to note is under these new rules, a landlord can no longer require rent to be paid in advance of a tenancy actually having been entered into. So the landlord and tenant must have agreed to a tenancy, the tenancy must have been granted before the landlord can take advanced rent. Now, holding deposits and tenancy deposits can still be taken in advance of the tenancy having been entered into. A period of the tenancy cannot exceed 1 month, and a period of the tenancy is determined by the rent payment frequency. So if rent is payable monthly, a single period of the periodic assured tenancy would be 1 month. If rent is payable every 2 weeks, a single period of the tenancy would be 2 weeks. And crucially, rent can no longer be taken in advance of more than 1 month. Now, where a tenancy agreement does require rent to be payable more than 1 month in advance, the law will automatically convert that back to a monthly rental. So let's say a tenancy states that rent must be paid in advance of £2,000 for every 2 months. The law would automatically convert that proportionally to £1,000 per month. There is also now a statutory limitation on guarantor liability in relation to rent, in that guarantors can no longer be liable for rent upon the death of a tenant. Now, should a tenant want to terminate this periodic assured tenancy, they now have a duty to give a minimum of 2 months' notice. Now, the landlord and tenant can agree to a lesser notice period, but in the case of joint tenants, all joint tenants must agree to that lesser notice period. But where a tenant does give a notice to quit, only one tenant has to give the notice to quit, not all joint tenants. And that does preserve the existing common law position that any joint tenant can give a notice to quit. It doesn't matter if the others knew of it, it doesn't matter if they approved of it, any joint tenant can give a notice to quit. Now, should a landlord wish to terminate the periodic assured tenancy, there are new grounds for possession which do include, amongst others, where a landlord needs to sell the property and where the landlord or a member of the landlord family needs to move back into the property for themselves. We'll be covering the new grounds for possession in much more detail in a separate video. So things like tenancy deposit protection, that all still is going to apply. Upon receiving a tenancy deposit, the landlord will still have to protect that within 30 days of having received it. The landlord will also have to provide the tenant or any relevant person that paid the deposit on the tenant's behalf the prescribed information within those same 30 days. So the tenancy deposit scheme requirement is still the same. They are going to apply to the periodic assured tenancy, but there are some new sanctions for non-compliance in relation to restrictions on serving a Section 8 notice. Again, that will be covered in a separate video. The Tenant Fees Act is also still going to apply as normal, so the rules in relation to holding deposits, what are permitted and what are prohibited payments are all effectively the same, with the addition that landlords cannot take advance rent before a tenancy being entered into, and rent cannot be payable more than 1 month in advance. Now, the circumstances in relation to which the periodic assured tenancy cannot be created are largely the same as they were in relation to the Assured Shorthold Tenancy Agreement. There's a couple of new additions relating to fixed term tenancies of 21 years or more that don't create this new type of tenancy, but otherwise the rules are largely the same. So for example, where the tenant is a company, that will not create the assured tenancy. Rental values of over £100,000 per year, certain student lets, resident landlords, holiday lets, and the list goes on, as is still set out in Schedule 1 of the Housing Act 1988. So going forward, the default tenancy type will be the periodic assured tenancy. And not only that, but landlords will now have an obligation to provide the tenant with a written statement of terms of the tenancy. So that does change the current position on its head, because at the moment, a statutory tenancy can be made in writing, but it can also be verbal. So there's going to be an obligation going forward for landlords to provide the tenant with a written statement of terms. Now, crucially, what the Renters' Rights Act states is that there will be subsequent regulations to come to set out what the written statement of terms must include. So it's going to be crucial that landlords comply not only with the requirement to give a written statement of terms, but to make sure that those written statement of terms do comply with the subsequent regulations to come. And once those regulations are published, we will then do a further video on what the written statement of terms must include. Now, unfortunately, there will be a financial penalty for non-compliance with that requirement. So there's going to be a lot to cover, but the core purpose of this video was to go through the structural changes to the tenancy type. And the crux of that really comes down to the end of the fixed term tenancy. What we've got going forward is a periodic assured tenancy, which is effectively an indefinite tenancy until either the landlord or the tenant terminates it. It is the end of the Section 21 notice, but there are new grounds for possession for landlords to terminate the tenancy, and we've now got limitations on what rent can be taken in advance and when, and limitations in relation to guarantor liability. But the Renters' Rights Act does bring much more change than just changes to the tenancy type. Local authorities will have new investigatory and enforcement powers in relation to housing. There'll be a new decent homes standard. Rent repayment orders are doubling from 12 months to 24 months, and much more. So we'll be covering as much as we possibly can through the series. Do subscribe to keep up to date with the changes. Do also visit our website at landlordadvice.co.uk, where you can read about the implementation dates as to when different provisions of the Renters' Rights Act comes into force.